Silence, silence. All stand, please, and remain standing. All persons having business before this honourable court are commanded to give their attendance, and they shall be heard. God save the Queen. Be seated, please.
I open the proceedings in the matter of Dayipu and others plaintiffs versus the two defendants, Ayers Mining Company and the Commonwealth of Australia, which is represented by the Solicitor General. I feel it's important to say at the outset that this case before this High Court is not merely one of Aborigines dispossessed of their ancestral land by the white man, finding in the activities of Ayers Mining Company a final assault on their beliefs. It's also a case that raises fundamental moral questions of great complexity. We must here discover whether the Aboriginal plaintiffs hold, in fact, in common law, a land rights title valid before 1788 to territories annexed by Governor Phillip, who, by hoisting the flag, claimed all of this vast continent for the British Crown.
At this point, Your Honour, it might assist the court if I could quote from Professor Ernst's discussion of the Damata Mala and Jamunda Mala. In this, he describes their claim to certain land, a claim which goes back to unthinkably ancient times, what they call their dream time. He also explains their clan relationship, which he identifies as a Mata-Mala combination. Professor Ernst even speaks of a Mata-Mala pair. The clan is essentially a patrilineal descent group, which is strictly exogamous. In other words, each member of the clan may marry only into the other half of the Mata-Mala combination. Now, this brings us to the concept of the so-called moiety. And I must stress that this area of anthropological theory is still highly speculative, not to say controversial. There are certain aspects of it, indeed, that lie within the realms of as yet unexplained mysteries.
Objection, Your Honour.
The Solicitor General.
The witness is putting forward as expert evidence what are clearly presumptions and theories. He should be asked to confine himself to proven facts.
Objection overruled. The court is competent to reach its own conclusions. Thank you, Mr. Coulthard. The witness will continue.
We're going to tell you about the land, so court can recognize the land that we live on. If the mining company coming and digging the earth or destroy the land, that meant that destroy the people. You're one of our leon, nango culture, nango, tanya nango, kanyina nango, kayol one of piano argo comelia, mine camaneo, panyamia camanyak. That mining company come and destroy the land and the feeling of the people, and for that dreaming, green ant dreaming. Paano nung arliyon ngayi, barnarango banam ngayi watango, kanan ko ngayi, nan ngaronyina panal, panganulin barnarango nam, nan ngar yurtuna kaya kan nganalichuna barnarango. If you're going to destroy the land, which is sacred land, a special area, dreaming land for green ants, if you're going to do, that means you're going to destroy the people, the green one, going to never come back again.
the counsel for the plaintiff please explain what is meant by that? In answer to a specific question relating to the precise limits of his territory, your witness answered with this gesture. And can you translate that into English?
Please, Your Honour.
Order. I call the Solicitor General to order.
And on the question of the exact expanse of the tribal territory, I hear a little long way. Now, what I'd like to know...
Mr. Coulthard, will you please restrain your boundless gift for irony?
With your indulgence, Your Honour, I'm very angry that evidence of this order should be admitted by the court, as well as repeated statements which are clearly hearsay by the Aboriginal witnesses.
I order that the transcript of these proceedings be so written as to include indications of descriptive gestures by the plaintiffs. And I assure Mr. Coulthard that this court will decide, in this case and in all others before it, what is and what is not admissible evidence.
Your Honour, I do not withdraw my objection.
Mr. Coulthard, I trust I don't need to remind you of the elaborate representations by the plaintiff's attorney in the case Nishaga Indians versus the Dominion of Canada on the admissibility of evidence by the tribal witnesses as long ago as 1871. And as to your remark about hearsay, I'd like to remind you of the decision in the case Angu versus Atta before the Privy Council of the Gold Coast, West Africa in 1916. You are, of course, familiar with that decision.
No, Your Honour, I'm sorry, I'm not.
You're not? Then would you be so kind as to inform yourself on this case? In Angu versus Atta, the African indigenes reporting on tribal customs gave evidence essentially founded in hearsay and in such overwhelming frequency that these testimonies became so widely attested as to condense into a palpable truth, and the court had to take judicial notice of them and henceforth recognize hearsay as admissible evidence. And in my view, the proceedings before this court today form a close parallel with those proceedings I have referred to.
Progress. Here, you talk about progress over and over again. And where does it lead the Aborigine? It is progress into nothingness. What have the last 200 years brought? Extinction. And where that wasn't radical enough, cultural extermination by the white civilization. Simple outright murder was only part of it.
Order. This court is not a forum for political oratory.
Let me get back to the disputed numerical concept of the Aborigine. Their relationship to quantities is distinguished completely from ours. It is not subject to abstract enumeration. Therefore, in most tribal languages, there are only numbers from 1 through to 3. Everything beyond that is called many. However, if a black cattleman has a herd of 600 cows together enclosed in a corral, he will know at a glance, without even counting, that 2 cows are missing. We still have rudiments of this ability. If, for example, a mother with 6 children is loading suitcases on a train in a crowd at the station, and one of the children escapes to the milk bar, that mother would know with a single glance, without counting, that one is missing.
Tol tu ngarawanga na ko don jang ngarapin kabay ngon malay rakko ngarapin ang kanya ngarajal ko nga ana ngarain do ko ngayon.
Mr. Malila, you were not called to the stand. Mr. Miliripi, could you please make this clear to Mr. Malila?
Your Honour, I'm afraid I cannot speak his language.
The plaintiff, Mr. Malila, was introduced to the court as mute at the start of these proceedings. I feel slightly confused. Is there anyone among the plaintiffs or witnesses who can translate?
The situation, Your Honour, is this man is the sacred custodian to the secrets of his tribe, and his tribe has died out. He is the sole and final survivor of his people, his clan. They call him the mute because there's nobody left on this earth for him to speak with.
Mr. Miliripi.
Your Honour, we are to show you most important sacred object where we belong and for the land. Please, I want you to remove the people. If they've seen this sacred object, the world must destroy.
Motion accepted. Ladies and gentlemen, will you please leave the court? Mr. Miliripi, you are aware, however, that for reasons concerning the very nature of these proceedings, the defendant as well as the court reporter must be present.
This sacred object is very, very important. This sacred object has been buried in the ground for 200 years. And now we come and show you to prove what the land is belong to the land is. Most important to our life, to our feeling.
And how should I record this, Your Honour?
Wooden objects carved with markings. The markings indecipherable. The significance of the markings not plain to this court.